Welcome back to the channel, everyone. Good to have you all here, and I hope you're all keeping well. For anyone new to the channel, I'm Cal, and I'm here as always to break down complex legal problems into simple and easy to action advice. And today I'm teaching you how to file in small claims court on your own and win, hopefully saving you time, money and stress. So let's get straight into it. So every year, thousands of people in the UK take someone to court for a small claim. Claims such as unpaid debts, faulty goods, issues with their landlords, and many people do it without a lawyer. But here's the truth. Small claims court is designed for ordinary people, not lawyers. If you are stressed about getting the ball rolling, I get it. But being prepared and organised is the key to winning in small claims court. My old litigation professor at uni always used to go on about this. The key to winning is organisation and having all your ducks in a row. So in this short video, I'm going to walk you through it step by step from the moment you decide to take action to gathering your evidence, to filing your claim, and what to expect at hearing. By the end of this video, you'll understand how to write a strong pre-action letter, how to file online without the solicitor, what to do if the other person fights back or ignores you, and how to prepare your evidence. Also, what happens at the hearing, and of course, how to actually get your money if you win. Along the way, I'll also point out a few differences if you're living in Scotland or Northern Ireland, since the systems there have their own quirks. And the best bit, as always, guys, I'm going to do it in just 10 minutes. So grab a drink, grab a pen, and let's begin. Now, firstly, you'll need to know whether your claim is actually a small claim or if it's a higher track claim. Let's do that now very quickly. So what counts as a small claim? Now, in England and Wales, a small claim usually means a case under £10,000 that doesn't involve serious legal complexity. Basically, small claims are smaller money disputes and everyday headaches. Okay, so now the vast majority of claims are under 10k, way under. If your claim is for over £10,000, it won't be assigned to a small claims track. It will go to a higher track where procedures are more formal, and you'll probably want a lawyer for this. Now, typical examples of small claims include things like I said, unpaid invoices, faulty goods, your landlord refusing to return your deposit, loans to friends that never got repaid, etc. Now, for our friends in Scotland and Northern Ireland, there are differences. The limit in Scotland is £5,000 under the simple procedure, and in Northern Ireland it's also £5,000. All right, so you have determined that you've got a small claim on your hands. The very first step isn't filling out any forms or paying any fees. It's trying one last time to resolve the issue outside of court. Courts actually expect you to do this. They actually expect you to make a reasonable effort to settle the dispute before filing a claim. This is important. In practice, this means sending a formal letter to the other side, outlining the problem itself and what you want, and giving them a deadline to respond. Lawyers call this letter a letter before action or letter before claim. Now, in this letter, listen to me, be polite but firm. Include details of what happened, a summary of the event, essentially what you're claiming and how much, a clear deadline to respond by, and a warning, guys, a warning that if they don't respond, you'll take legal action. Now, keep a copy and send it recorded delivery. You need a paper trail. If you end up in court, this letter proves that you tried to settle things reasonably outside of court, and the courts love this. Which leads me to a quick pro tip. To show that you are aware of the rules, you can, in your letter, say something like this. I refer you to the practice direction of pre-action conduct under the civil procedure rules. This is legal jargon, I know it, but it's legal jargon for, I know I'm supposed to try and settle this first, and if you ignore this letter, the court could penalise you for not responding. It shows to the other side that you are knowledgeable. Now, one of three things will happen. Number one, they might agree and pay up. Great, no need for court. You've solved it yourself. This happens far more often than you might think when you send a formal, well-reasoned, well-drafted letter that shows that you understand the law. Number two, then they might reply and disagree with you. Maybe they're offering a partial refund or denying fault. If they give you reasons, that's great. You've gained an insight into their likely defence and you can prepare counter evidence for each point that they've disputed. They could also threaten a counterclaim. In other words, actually, you owe me money. Now, don't panic. Just gather proof to refute any false claims. If you are confident in your claim, you will be fine. And option number three is they just ignore you completely. Unfortunately, guys, this does happen a lot. People often think they can ignore you because they don't think you'll actually go to court. But after 14 days or whatever deadline that you gave them in your letter, With no meaningful response, it's time to proceed with a claim. Don't be afraid to get the ball rolling. Quick one before we begin on the next section, guys. I will never ask you at any point to hit my subscribe button, only that you give me the opportunity to earn it from you with this content that I've made for you. So if at the end of this video you feel like you have learnt or liked or taken anything of value from it, then please feel free to do so. All right, step 2 then, filing your claim. Again, not that difficult, guys. If the deadline passes and nothing's been resolved, it's time to file. Now, don't worry, it sounds more intimidating than it is. Now, there are 2 ways to file your claim: online and via post. Option A, online. The government provides a very, very simple and easy online portal to submit your claim for you. The new system is called the Civil Money Claims, CMC. You can use this if you're claiming a specific amount under £10,000, like I said, and meet a few very simple criteria. It's very user-friendly. You just create an account, you fill in the details of the claim, and the system guides you through everything. It guides you through all the forms. Now, I've attached a link to this service in the description, so check that out. Alternatively, there is the older service, which is the Money Claims Online service, MCOL. You might have heard of this, which you might use for some reason if the CMC isn't available to you. MCOL is also an online form. It does largely the same thing, and I've attached a link down in the description to that service as well. MCOL is great for the most straightforward money claims where you don't really expect there to be much of a lengthy dispute, and I really highly recommend it. Again, the link for that is in the description. Now, option B is the paper route. If you don't want to or you can't file online for some reason, you can do it the old-fashioned way. You fill out a claim form. It's called Claim Form N1 by post, and hand it to or deliver it to the court. You can download the form again in the description below. But look, whether online or paper, the information that you need to provide in this is basically the same. Who you are and who are you suing. What happened, basically just a brief statement of the facts. How much you're claiming for. Any interest that you're claiming. Remember, you can claim statutory interest on whatever money is owed to you, often 8% per year if it's appropriate. Make sure to include this line if you can in the box to ensure that you're also claiming for interest. Do not be afraid to include it. And finally, what do you want? If you win, make sure to include that. Usually you just put the money plus the interest and the court fee. If you need something else other than money, for example, you need the court to order that someone does something, like does some work or returns an item, that can complicate things a bit. But small claims can handle simple orders too. Just be very clear about what they are. Now, paying the court fee is next. There is a fee to start a claim. It varies depending on the amount that you're claiming, but it's not that much. If you're on a low income or benefits, by the way, you might qualify for help with fees scheme. So check the Citizens Advice link that again I put in the description to see if you can get a reduction or not have to pay the court fee at all. Now that's it, guys. The hard part of initiating the claim is actually done. Just make sure everything is accurate, what you put in. Names spelt right, addresses correct, so there are absolutely no hiccups in serving the papers on that person. That's very important. Now, what happens after the claim is filed? Well, once the claim is filed, the court sends the claim to the defendant. They have 14 days to respond to it, or 28 days if they acknowledge it. And that leads us on to step 3 then, which is dealing with the defendant's response. So if you filed your claim properly, congratulations, that's the big part done. Now you need to see how the defendant responds to you. There are a few possibilities here. Each leads to a different next step. Number 1, no response from the defendant. If you get no response from the defendant, this means you can win by default. If the defendant ignores the claim entirely, meaning the deadline passes without a reply, you are entitled to request from the court a judgment in default. It isn't automatic though, guys. You can't just wait for it to come. You must actually ask for the judgment to be made, but usually it's just a very quick administrative step. The second reply they might do is admit owing the money. Now, the second option is that they actually agree with your claim or offer a settlement that you find acceptable. You can settle at this stage if you want, and the court will then enter into a judgment for that settled amount. The third outcome, and one of the most common outcomes, is that they admit part of your claim. For example, I owe £300, not £500 that you asked for. The court will inform you of that offer. It will inform you that an offer is made, and you'll typically have a chance to accept or decline the defendant's offer. If you decline, you'll proceed straight to a court hearing. I, however, recommend considering a settlement if ever you are not completely 100% sure of the merits of your claim. Now, the fourth option is that they disagree with you completely and file a defense. Now, if the defendant does dispute your claim and send in a defense statement explaining why they deny owing what you claimed, then the case will, yes, move forward in the court process, and the court will send you directions for a court hearing. Now, very quick inside tip, the court will now encourage you one more time to consider mediation. In England and Wales, when you're filing in small claims, you actually have access to a free small claims mediation service, guys. Take advantage of this. A lot of cases settle in mediation, because once both sides actually meet and talk, they do find a middle ground. It's confidential, and nothing that you discuss in that mediation can be used in court. Try it honestly. If not, the court will set a hearing date and send you notice of that hearing date. You usually get 21 days notice of the hearing date. Also, make sure to pay the hearing fee, guys. Pay it by the deadline, or the case could be thrown out. That is extremely important. Do not miss any deadlines. Finally then, I'm going to quickly explain to you how to prepare for court hearing. Now, as I said before, the best piece of advice that my uni professors used to tell me when it came to litigation, when it came to civil procedure, is that when it comes to court, the most important thing you need to worry about is having your ducks in a row, having everything in order in advance, having your documentation prepared for every defense. This is the key to success in a court hearing. So step 4 then, let's look at preparing for court. Preparation is everything. You will need to follow the court's directions, like I said before, of which they will send you. For example, when to submit documents to the court or the other side. Do not miss these deadlines, okay? Now is the time to compile all the proof that supports your story. What counts as evidence? Well, anything relevant that helps prove the facts in support of your case. Your evidence might include things like receipts or invoices, timesheets, contracts, photos, screenshots, maybe even like emails, texts, bank statements. Put it all in order, in date order, and label everything clearly. Send copies to the court and to the other side on time, as you are directed to. If you have witnesses as well, let them know the hearing date, or you can just get a witness signed statement. Also, here's a personal tip for you. Write out your story in your own words. Practice explaining it very clearly. You don't need to sound like a lawyer. Just be honest and confident and clear in what you're saying. Judges love this. They do not love rambling, unclear and uncertain verbiage. And step 5 then is the hearing. So at the hearing, remember, stay polite, stay calm and stick to the facts. Do not, whatever you do, get cocky or seem like a know-it-all. This is so common and judges do not react well to that, believe me. Remember to stick to the relevant facts. What happened, when, what proof you have that that money is owed. The judge may interrupt with questions. That's perfectly normal. It's also natural to feel defensive. If they say things to you that you disagree with, that is natural, but you will get a chance to reply or clarify. After both sides have then had their say, the judge will say who wins and what amount is ordered. This is the judgment. If you win, great. The judge will likely order the defendant to pay you a certain amount, an agreed amount, within 14 days. Now, if you lose, the judge will just dismiss your claim or only allow part of your claim, and they'll give you reasons why. Now, guys, for a very important final tip, we need to talk about getting paid. Sadly, winning doesn't always mean you get paid. You will have to enforce your judgment. And this does warrant a separate video entirely, as I don't want to swamp you with too much information all at once. So subscribe if you want to keep an eye out for that video, which is coming in a few weeks' time. But look, there can be difficulties. There is often difficulties actually forcing the defendant to actually pay up. And last, but certainly not least, what about your legal costs? Who pays them? Well, look, in small claims court, cost orders are very, very limited. Usually the losing side does not have to pay the winner's legal costs, because that's really not allowed aside from fixed small amounts. But remember, there may be no lawyers involved in this anyway, so there isn't much legal cost to actually claim for. The exceptions of things that you may be able to claim for is things like fixed court fees, possibly a small fixed amount for loss of earnings for attending the hearing and travel expenses and so forth. So, all right, guys, so we've covered a lot. Well done for staying until this point. You clearly are here to learn something useful, and I commend you for that. So let's zoom out very quickly. Small claims are absolutely doable by yourself and without representation. I want to know your stories and your experiences with small claims court. Have you tried this process? How did it go? And did anything go wrong? Do you have any tips for anyone else watching? Let's get a discussion going down in the comments so we can all help each other. And remember, this content is educational only, guys. It's not a substitute for personalized legal advice, okay? That said, I'll see you in the next video.